Good afternoon, everyone, and welcome to the latest of Fieldfisher's Privacy webinar series. My name is Renzo Marchini, and I'm a partner in the privacy practice in London. Thank you so much for joining us. Today's webinar is called, perhaps rather unimaginatively, International Data Transfers. It's safe to say that topic has seen a number of developments over the past few years, and that momentum is not looking to slow down anytime soon. The DPAs are beginning to flex their muscles in the wake of Schrems II. We may even get a privacy shield, more on that later. The main motivation for today's talk, however, the timing of it, is the coming into force next Monday of the new UK SCCs, or should I say IDTAs, unless Parliament throws them out, of course, which must be extremely unlikely to happen, but could still theoretically happen. They have been a long time coming. The EU SCCs were finalised in June last year, and the end of the second of two transitional periods for those is upon us in December this year. It's a shame that there could not be coordination of those periods, but of course that's a consequence of Brexit and of the UK not wanting to follow too closely what the EU is doing. So the main piece today will be on the new UK transfer tool and the UK addendum to the EU SCCs. Natalie Barnfield, a senior associate in our team, will talk about those, both the substance and also practical issues of implementation. Following that, if he can join us, but he's having technical difficulties at the moment, my colleague Rob Fett, an associate in our team, will talk about the case that's got a lot of attention recently, the decision of the Austrian DPA on the use of Google Analytics and its violation of Chapter 5, and the Guile case that followed in its wake. I'll begin with setting the scene and talking about some of the latest thinking on undertaking Schrems-inspired transfer impact assessments. We will finish within the hour, that is at 5 p.m. But before I get going properly, a few housekeeping points about our webinar. Please do ask us questions using the question function as we go along. You should see it on your screen. We may be able to take them at convenient points as we go through, so do keep them coming, and we certainly have left time at the end. If we do run out of time to answer all questions, we'll try and respond over the next couple of weeks in writing. Next week, we'll be sending you a copy of our slides, indeed even a recording, which will also be posted on our YouTube channel. So don't feel as if you need to scribble everything down as we go along. A couple of other points. Do please subscribe to our blog, which has a regular set of posts on topical issues, and also to our YouTube channel. And do keep an eye out also for more webinars over the coming months. So the agenda, I'll, as I say, kick off with a recap of where we are, over to Natalie on UK transfer documents, Rob, if he's going to join us, Google Analytics and Privacy Shield, and then some Q&A. So with no further ado to the substance, then just a recap of what's happened and where we are at. It's 4 years now since GDPR came into force, and can you believe it's 18 months, 19 months since the actual Schrems II decision, and people still trying to figure out what it all means, and will Europe become a data island? At the end of 2020, we had the draft EU SCCs for consultation, the draft EDPB recommendations on dealing with Schrems out for consultation, followed by Brexit. And of course, Brexit meant we end up with divergence. We've got new EU SCCs and indeed finalised EDPB recommendations, which don't have effect in the UK, but more on that later, and bringing us right up to date in March this year. Now we've got the UK instrument about to come into force. So I think everyone on the call is pretty much sick and tired, I'm sure, of Schrems, but a very quick reminder of it all. Privacy Shield died, SCCs declared to be valid, but additional measures may be required. exporter verification is needed of third country laws on a case-by-case basis, and that's what I'll spend in a few minutes talking about, the sort of ways we're seeing people deal with it. If you verify that the laws can actually protect the data sufficiently, you can just execute the SCCs and transfer the data. If you fail your assessment, you're supposed to try to find supplementary measures which will fix the gaps. If you can find those measures, then you can sign the SCCs, put the measures in place, transfer the data. And if you can't, then your data must stay in Europe. So the EDPB recommendations, which now is the Bible of dealing with transfers, finalized at the same time as the SCCs last summer, set out a 8-phase approach to this. Phase 1, you know your transfers. You can't decide whether data is going to be adequately protected unless you know where it is, who's got it. When you know where it is and who's got it, how do you transfer it to them in compliance with Chapter 5? Is it an adequate jurisdiction? Can you have a transfer tool to make sure that the data is going to be transferred if it's not adequate? And when you've done that, you have to assess the laws. And this is the sticky point that people have been struggling with. How do you judge whether the SCCs themselves are going to be okay? If you do, and I'll come to that in a moment, if you do judge they're okay, you might have to put supplementary measures in place and you can transfer. If there are no supplementary measures, then you mustn't transfer. And of course, I haven't got time to go into too much detail here. Use cases 5 and use cases 6, data in the clear, the problem with that, which a lot of people are still struggling with. So the thing that I particularly want to draw out from the EDPB recommendations is paragraph 47, which we've spent a lot of time talking to our clients about, which did not appear in the consultation draft in November 2020. And if those of you that were familiar with the progress of this might remember that the draft SCCs that were published for consultation by the Commission and the EDPB draft recommendations had a difference in the approach as to how you take into account actual practical experience of the importer under the problematic rules. The Commission said in their draft SCCs, and indeed now in their final SCCs, that you can take into account the practical experience of prior instances of requests under troublesome laws. It seems that the political battle behind the scenes was won by the Commission, and the EDPB recommendations do also reflect that you can take historic practices into account. Now, that is something that allows a lot of vanilla transfers to proceed under the SCCs without much more. Now, there's a tail in a sting in the tail in paragraph 47. It does also, it must be said, say that it by itself, the absence of prior instances cannot be decisive in relation to effectiveness, but you will be able to consider the prior instances together with other information available from other sources. So it's part of the mix, the fact that your particular importer, your provider of a bog standard CRM system of whatever it is has never received a FISA 702 request. You can take it into account. It's not decisive itself. Now, Rob will come on to Google Analytics. I see he's joined us in a few minutes' time, and I'm sure he'll talk about this. He will talk about this. Has the Austrian DPA taken this consideration into account in its decision? Has the CNIL taken it into account? I think people still are, but it's hard to reconcile with the approach of these supervisory authorities at the moment. What I want to spend the next 5 minutes or so talking about is how we're seeing our clients and people in the market actually deal with the EDPB recommendations and doing transfer impact assessments. And broadly, there's a spectrum of approaches, and I want to sort of give you a flavor of things at different sides and ends of that spectrum. First of all, is an approach where you faithfully go through every single consideration that the EDPB recommendations ask you to do. If you remember a few slides ago, yeah, step 1, know your transfer. The form here, which is the Field Fisher transfer impact assessment form. I know some clients on the call will have seen this. Know your transfers. You fill it in. You go on to phase 2. What is the part 2? What is the transfer mechanism being used? I won't go through it all. And then part 3, dealing with the actual analysis of the law of a particular country. And you fill this in and you do an analysis. So again, I picked on the US as an example. You do an analysis in accordance with all the questions that the EDPB asks you to ask in relation to FISA 702. Questions such as, has the recipient actually received a law enforcement request? And when you go through all those questions, and you can see we've got 54 rows in our form, and I've seen other law firms and other advisors' forms as well. They're all quite long and they're very detailed. At the end of it all, you undertake a risk assessment to decide whether or not you can go ahead with the transfer. So this is quite heavy. I mean, it's paper heavy. It's asking lots of questions of vendors, but it does faithfully, as I say, track what the EDPB would ask you to track, with hopefully the answer at the end that you can indeed carry on in most circumstances with business as usual. But it's, I say, heavy, resource intensive. And if you're an organization, as some of our clients are, with hundreds of contracts and vendor arrangements being entered into all the time, it is really a Rolls-Royce approach to transfers. So what we're also seeing is some organizations taking a more risk-based approach. And I just want to give you an indication of one approach to doing it in a lighter fashion. First of all, rather than analyze the laws of a particular country in that detailed manner against the essential guarantees promulgated by the EDPB, is you look for a proxy for privacy risk, and I'll come to that in a moment. You also then don't analyze the data to the nth degree, but you put them into buckets, so you assign risk in relation to different types of data. You calculate an overall risk with a matrix and you make an adjustment. So the proxy for privacy risk that we've seen some people use is to look at Democracy Index, which is a publication by The Economist, which characterizes different countries as from an autocracy to a mature democracy. And as perhaps an amusing or not so amusing aside, the UK was recently downgraded from mature democracy to flawed democracy because of such things as the government's attempt to prorogue Parliament during the Brexit stuff. And so you look at different countries and you put them in different buckets without going to that length of analysis. Just to show you how this is a little bit of you've got to take a view here and take a risk here. It's certainly not sanctioned by the regulators. Where would you put the USA? The US, of course, the subject matter of the Schrems decision, is high risk. I mean, no regulator is going to tell you not. But if you look at this type of proxy, well, the US isn't going to be high risk. It's not the same as China, Iran, Iraq, or so on. One of the problems with the more robust approach, though, is when you analyze countries' laws, and if you look at the essential guarantees document, which asks you to inquire as to whether or not a particular country has the rule of law, and you ask local council to opine on, does your country recognize constitutional right of the rule of law, or whatever it might be, it's not common in all the 25 to 30 that we've now done for clients that I don't think I've ever got an answer along the lines of, no, our country does not recognize the rule of law. It just doesn't, you don't get those answers back. So even doing the robust approach is arguably flawed, because you're still relying on a view of the law which might not actually reflect the reality. So you analyze risk of a country, and you analyze the risk of data. in this more risk-based approach, which I'm illustrating. Anonymous data, clearly no risk. Data which might be pseudonymized, device-related data, email addresses, basic contact identifiers, low risk. And at the other end of the spectrum, special category data, of course, that's going to be high risk, we'll say a regulator. So you've got risk for country, you've got risk for data, and you have a matrix to be calibrated to the organization's taste for risk, and you multiply and you find out, and hopefully you get an answer which allows you to put in place achievable supplementary measures at the worst case scenario, rather than, if you end up in the bottom right hand corner there, you will not be able to transfer data. So I hope it gives you a flavour of different approaches. Of course, these are just approaches; they're not sanctioned by regulators by any means, but allows some organisations to get comfortable that they've got a story to tell. Stakeholders, might it be their customers if they're in the processor side of the equation, to their works councils, to the consumer base and user groups, to regulators and so on, that at least thought about it and done something. And now I want to hand over to Natalie, who will talk us through the UK transfer documents. Over to you, Natalie.
Thank you, Renzo. And just before I do, we've actually had a question come through asking about the TIA template that you were talking about and whether or not it's available on our website, Renzo. Do you want to take that before I go on to talk about UK transfers?
It's not available on our website. We do sell it to clients, but or to people who want to be clients. But so a lot of our clients will have seen this. But there are some templates out there which are freely available. And so whoever asked that question, please come back to us.
Thank you. So, and good afternoon, everyone. So I'm going to take us through an overview of the position, the UK data transfer position, and also have a look at two new UK data transfer documents. So Renzo, can you take me to the next slide, please? So for those of you who've been following international data transfers closely, you'll be familiar with the fact that last year, the ICO carried out a consultation on UK data transfers. And during that consultation, they looked at three key documents. The first was the UK's International Data Transfer Agreement, or IDTA. The second was the UK Addendum to the EU SCCs. And the third was the International Transfer Risk Assessment and Tool. So the first two of those documents were laid before Parliament last month. And as Renzo said earlier, they're due to come into effect next week, so the 21st of March. And in terms of what they are, well, they're documents that were produced by the ICO as mechanisms that can be used to ensure appropriate safeguards for restrictive transfers under the UK GDPR. So although they do constitute appropriate safeguards, a key point is that obviously they don't negate the need to carry out a transfer risk assessment, as they're referred to in the UK under the UK GDPR. You'll still need to carry out a risk assessment for UK transfers in order to identify what, if any, other supplementary measures you'll need to put in place to ensure appropriate protections or appropriate safety of your data transfer. So just before I go on to look at the documents in more detail, Renzo, could you take me to the next slide, please? I thought it might just be worthwhile taking a step back just to see where the documents fit, if you like, in the UK data transfer picture. So when you're considering UK data transfers, you'll need to ask yourself first, is this a restrictive transfer? And so on this specific point, the ICO has actually updated its guidance, and it makes clear that you are dealing with a restricted transfer if the data processing is caught by the UK GDPR. So, if you are established in the UK or if you're offering goods and services into the UK, and if you're transferring personal data out of the UK to a receiver that is a legally distinct company. So a key point to note is that for UK purposes, if you're transferring data to a branch that's outside of the UK, but is the same entity, it won't constitute a restricted transfer that needs to be protected. So that's the first point, is once you've established that you've got a restricted transfer, you will then go on to consider whether or not there are any adequacy regulations that apply to the territory that you're transferring the data to. So that's much like the position in under the European GDPR, European adequacy decisions. So assuming that the territory that you're transferring the data to isn't subject to an adequacy regulation, you'll then need to consider what appropriate safeguards you can use to protect your data. So under the UK GDPR, much like the EU GDPR, there are a number of options, but the most common option to use is the standard contractual clauses. And the two documents that we're talking about today constitutes the UK's version of the standard contractual clauses. So that's the UK IDTA and the UK Addendum to the EU SCCs. And obviously, as part of step 3, Renzo's already touched on transfer risk assessments, or transfer impact assessments as they're referred to at a European level. They'll also need to be conducted in tandem with considering your appropriate safeguards to identify what, if any, supplementary measures you need to add to your standard contractual clauses for UK purposes. So that's just a snapshot. So if we turn to the documents themselves, if you wouldn't mind, next slide, thank you, Renzo. So I'm going to start with the UK Addendum to the EU SCCs. And the reason for doing this is because most of our clients, and we expect most businesses across the board, prefer to use the UK Addendum to the EU SCCs. And the reason for that is probably obvious. It's, essentially most organizations nowadays, they're going to be dealing with data transfers that are subject to both the EU GDPR and the UK GDPR. So being able to use the UK Addendum means that you don't have to have two sets of contractual arrangements. You don't have to have two different sets of standard contractual clauses. You're able to just rely on the EU SCCs for both your EU and UK data transfers. So I've sort of explained what its purpose is. I think it does basically exactly what it says on the tin. So it essentially allows you to rely on the EU SCCs for UK data transfers. In terms of its contents, it's relatively short, 9 pages. Again, I say relatively, in the world of data protection, 9 pages is definitely short. And it's divided into 2 parts. So the first part is comprised of a series of tables that you have to populate with details about your data transfer. And the way that it works is that the information you're asked to populate for the purposes of Table 1 to the Addendum basically aligns with the information that you would have to provide if you were using the EU SCCs. So you have to specify, which module of the EU SCCs you'd be using for the purposes of your transfer. Is it module 1 for C2C transfers, for example? And similarly, you'd have to specify which of the optional clauses within the EU SCCs you're relying on. Part 2 is the mandatory clauses. So this is the part of the addendum that can't be amended. And essentially, it's comprised of amendments that make the EU SCCs work for UK transfers. So pretty straightforward and obvious. It makes obvious amendments. References to Europe are changed to UK, for example. Why use it over the IDTA? I think I've probably, explained the most important factor, which is sort of it eases your administrative burden. It's short, it's simple. You only want to maintain one transfer mechanism over time. And the other point, which I suppose is related, is that it's inevitably going to avoid deal friction. So if you're dealing with customer contracts and that you've got sort of UK data transfers and EU data transfers under, you don't want customers having to review 2 different sets of standard contractual clauses. And I suppose there's a possibility that some customers will be more familiar with the EU SCCs than they will be with the UK IDTA. Next slide, please, Renzo.
Before I do that, Natalie, just to add to that, because someone has asked a question, which is can they only be used if you have an EU transfer at the same time? And to which the answer is no. This is a UK transfer mechanism, and even if there's no EU GDPR protected data, you can still use the UK Addendum. At least I think I'm right on that, Natalie.
Yeah, correct.
Thank you.
So if we now turn to the UK IDTA itself, again, what's its purpose? It's the UK's equivalent of the EU SCCs in essence. It's divided into 4 parts. The first part, again, is it's divided into tables that you would populate with details around your data transfer. So, again, specifying whether or not it's a controller to controller, controller to processor, etc. transfer. You might include details of your linked agreement, so an agreement that the data transfer is being made under. You'll have to specify what data is being transferred, the data subjects, the purposes of the transfer, etc. So all relatively familiar stuff, and that is common across both the UK IDTA and the EU SCCs, although it's presented slightly differently and there are some additional questions in the UK IDTA. There is a second part 2. This is essentially a sort of placeholder, if you like, for you to plug in any supplementary measures that you've identified during your transfer risk assessment stage. And that is a difference to the EU SCCs. There isn't a specific place that supplementary measures are supposed to kind of be added to the EU SCCs, and that's a difference to the UK IDTA. Usually for EU SCC purposes, you'd plug in supplementary measures, perhaps into your technical and organisational security measures, for example. So it's more drawn to your attention within the UK IDTA. There's also a placeholder for additional commercial clauses that you might want to agree between yourselves, or alternatively, you can just refer to the linked agreement. And part 4 is where the mandatory clauses live. And again, they obviously can't be amended. So next slide, please, Renzo. And just in terms of the mandatory clauses themselves, a few observations on these. So obviously you won't be surprised to hear that they cover much of the same substance as the EU SCCs. So, you'll see obligations relating to data breaches, data subject rights, restrictions on onward transfers, details around, how to handle law enforcement requests and the like. So that's, familiar territory. One way that they do significantly differ to the EU SCCs is their structure. So there's only one set of terms for all data transfers, and that's by contrast to the EU SCCs, which obviously deals with terms in modules. So you have 4 modules under the EU SCCs which have to be used for different types of transfer. So module 1, again, for your controller to controller transfers, and different modules for controller to processor, processor to processor. So although that's quite clear, and it's quite clear how to use them under the EU SCCs, it does mean that if you don't have a transfer scenario that falls squarely within those modules, the terms don't quite work. So that is one benefit of the UK IDTA, is that by having one set of terms, they can actually be used for more types of transfers than the EU SCCs. And just to give you an example of where that might arise, if you've got a processor, for example, based in the UK and wanting to make a transfer to another organisation that isn't its processor or sub-processor and isn't its controller, it doesn't squarely fall within any of the EU SCC modules. And just to expand on that example, the one way in which it could be lawfully asked to transfer data to an entity that isn't its processor or its controller might be, for example, if it's being asked to transfer the data to another processor of its controller. So in that scenario, it could be covered under the UK IDTA, but wouldn't obviously be covered by one of the modules under the EU SCCs. So it can be used for more types of transfers. The other point is that it doesn't address all of the Article 28 terms. Now, some see this as a positive and others see this as a negative. So on the positive side, it means that you there isn't the kind of possibility of conflicts between Article 28 terms in the UK IDTA and Article 28 terms that you might have in a linked agreement. So often you'll see that parties want to add a bit more colour to Article 28 terms in a linked agreement, you know, some more detail around perhaps timings or timeframes for notifications or helping with data subject rights, or even cost allocations for audits. And where you do have additional detail in the linked agreement, there is the potential for potential conflict, two potentials there. So by not having them in the IDTA, you're removing that risk. And then the downside, of course, is that by not having them in the IDTA, you have to address them somewhere else. So not necessarily a plus or a con, depends who you are, but just an observation. And then finally, these 2 points, I suppose I've already kind of touched on these, is that they are quite easy to follow, they're user-friendly, and they do provide some drafting flexibility. So next slide, please, Renzo. Thank you. So notwithstanding some of the benefits that the IDTA provides, to our mind, the scales still seem heavily weighted in favour of the UK addendum. Again, it's one approach, covers both UK and EU law compliance, removes administrative burden, paperwork, and probably deal friction, and is, in our view, well, in our experience, certainly the preferred approach of most of our clients at the moment. Next slide, please, Renzo. So if you want some more differences on the UK IDTA and the EU SCCs, we have got a blog on this, which I've linked to in the slides. And within the blog, we've also got a comparison table, which sets out a sort of side-by-side comparison of each of the provisions of the EU SCCs and UK IDTA and compares the two. So that's a really helpful document if you do want some more detail. And next slide, please, Renzo.
I was on mute. Before we do that, Natalie, there's a couple of questions in relation to incorporation. One's a bit long, so I might be not getting the point, but one of them is easier. Is it possible to include the mandatory clauses by reference, or do you need to actually append them to a wet signature? Who has a wet signature these days anyway? But you know what I mean.
Yes, you absolutely can incorporate them by reference.
Good, I thought so. And someone else then said, I think I understand the question correctly. They're quoting a bit of the EU SCCs at me, but I think the gist of the question is, can you agree them by email? And I think
good question.
The answer must be yes.
Yeah,
I think so.
mean,
It's a question of contractual law, isn't it?
Exactly. As long as you're satisfying the requirements of offer acceptance and contractual requirements, then I don't see why not.
Yeah, thank you.
Timescales, just a point on timescales. So the yellow boxes here indicate the position in the UK, and then the green boxes indicate the position in Europe. So looking at us today, indicated by the red today, obviously the two documents that I've been talking about, they come into effect on the 21st of March, so next week. We then have a little bit of grace period until the 21st of September, when you are still able to rely on the old EU SCCs for new deals. So if you do have any sort of legacy templates that have old language which incorporate the old EU SCCs, they will still be valid, and you can still sort of enter into those agreements until the 21st of September. But after that point, you need to be using the new documents for new deals. And then there is quite a healthy grace period until the 21st of March 2024, during which period, if you are relying on the old EU SCCs for data transfers, they will remain valid. So it's just that from the 21st of March 2024, all deals, new and old, need to be relying on the new documents. So that is a marked difference. Renzo, next slide, please, to the position at the European level. And you'll see on the slide here, the position at the EU level is that by the end of this year, you're expected to be using all of your transfers should be covered by the new EU SCCs. So there is an unhelpful discrepancy there, and is something just to keep in mind when you are sort of going through your repapering exercise, that although you may have longer for the purposes of UK transfers, the same isn't true of your EU transfers. Next slide. I think that takes me to the end.
That might be. Can I just take a couple other questions which have come up on these topics? Thank you very much, Natalie. It was great. First of all, a few people have now asked, are we going to be circulating the slides? Yes, we will be circulating the slides, and indeed a recording to all attendees. Is my understanding correct, says the question, that the UK addendum is only required for UK companies, but not if an EU company transfers both EU and UK data? I don't think that's correct in the sense that there's nothing stopping an EU company, of course, using the UK addendum when they transfer UK protected data. And so absolutely, they need to do something under UK GDPR if there's UK protected data, and the choices will be, as Natalie has said, the UK addendum, which incorporates the EU SCCs, which seems the practical thing to do if you've also got EU data, or the UK IDTA on its own, and in parallel have the EU SCCs for the EU data. But I'll take some more questions at the end if we still have time. I think we will have. Over to you, Rob.
Good afternoon, everyone, or good morning if you're in the US. So I'm going to talk to you a little bit about some recent Google Analytics decisions, as some of you may be a little concerned about the impact of those on transfers of personal data to the US. So next slide, please. So shortly after the Schrems II decision, almost coming up to a couple of years ago, Max Schrems decided to have some more fun, and he, under his NOYB organization, which is based in Austria, issued 101 complaints, just like the Dalmatians, to DPAs around Europe about various companies' use of Google Analytics and also Facebook Connect. And NOYB claims that these were not in compliance with the Schrems II ruling. And these 101 companies consisted of at least 2 companies, one in Austria and one in France, who were subject to some recent decisions, which we'll go on to discuss. Next slide, please. So following NOYB's complaint, the Austrian Data Protection Authority in January of this year published its decision concerning the use of Google Analytics by a health website called NetDoctor. And the Austrian DPA held that this website operator had violated the data transfer terms of the GDPR by failing to ensure that the personal data that was transferred to Google in the US had been afforded an adequate level of protection. So amongst the Austrian DPA's findings were first that the data collected by Google Analytics included some unique identification numbers, IP addresses, and other browser parameters, and that these constituted personal data within the meaning of the GDPR. Second, the data was not pseudonymous because these unique identification numbers, when combined with various other data, constituted personal data, and in particular because the IP anonymization feature within Google Analytics had not been correctly implemented by the website operator. A third conclusion was that the data was made available to Google LLC in the US and therefore transferred to the US under the meaning of the GDPR transfer mechanisms. And this was done on the basis of the old EU standard contractual clauses, so not those new clauses that we've been discussing today. And so that does leave, at least theoretically, the possibility as to what conclusion the DPA would have come to had the transfer been based on the new SCCs. So that's a possible argument to make. Fourth, the DPA had also referred to the draft EDPB guidelines on data transfers rather than the finalised guidance. And the old guidance took a much more conservative view than the final guidelines. So that's also something to bear in mind. Fifth, Google was qualified as an electronic communications service provider under Section 702 of FISA. This was something that's kind of freely admitted by Google itself, and Google also publishes transparency reports discussing its own requests that it receives from US government authorities. Sixth, the supplementary measures implemented by Google, in addition to the SCCs, were found to be insufficient by the Austrian DPA. Seventh, the website operator, as the data exporter, was solely responsible under the GDPR, rather than Google, who was the data importer. That will become relevant to some of the mitigation points we'll talk about later. And finally, the decision made no comment about the applicability of other mechanisms that are permitted under the GDPR, particularly explicit consent, which is one of the derogations under Article 49. And so this was not discussed in the decision, and no comment was made about whether or not it could have been relied upon. Then after the Austrian decision came a similar decision from the CNIL in France. This sort of followed very similar lines to the Austrian decision, but there are a couple of other points worth mentioning. So first, in that particular case, it wasn't clear whether the data was anonymized or if indeed the entire IP address was transmitted to the US. So I think you've always got to bear in mind the factual considerations in your particular data transfer scenario. And but more detail was discussed about the derogations under the GDPR, under Article 49. So firstly, the decision states that consent was not possible in this particular case, and this was because the company had not provided any information to website visitors informing them of potential risks of transfer. And therefore, the conditions of Article 49 1A in the derogations was not satisfied. And secondly, the company could not rely on contractual necessity under Article 49 1B because it had not provided any evidence as to how that could be used. And so what do these decisions mean? Well, I think it does leave open the possibility, at least in some cases, that explicit consent or contractual necessity may be possible routes for transfer to the US. But this is not going to be straightforward for organisations. There are some considerable problems with both mechanisms, which should not be taken lightly. Notably, these are that the derogations in the GDPR are to be used on an exceptional basis. They shouldn't be used for kind of regular routine transfers. And secondly, explicit consent has its own issues. So a lot of information would have to be provided to data subjects about the risks of the transfer. And this might not be something which is easily done, for example, in a cookie consent sort of tool. And contractual necessity can also be difficult because you're going to have to demonstrate that the processing is truly necessary for the contract with the individual. And that may not always be the case, particularly for things like analytics. Next slide, please. And so is it just Austria and France that have made similar decisions? The answer is no. There are a couple of other countries which have commented on these decisions. In Norway, they've suggested that they are aligned with the Austrian decision, and Denmark has also called for some common interpretation of the rules on data transfers. So where does this leave us? Next slide, please. So I think a lot of companies are considering how to react to these two decisions. For some companies, they might sort of take a wait and see approach, see what other regulators do, particularly in their own countries, see what other enforcement comes about. Whereas other companies who may feel they are a little bit more at risk of these decisions may decide to adapt some of their data transfer processing. But I think one point, which we will come on to in a bit more detail, is that all of this could be a little bit sort of a moot point, really, if Privacy Shield, if there's a replacement to that in the near future. So let's now go on to discuss some of the practical points that organisations can be making, and how they can be reacting to this decision. So first of all, I think we would all agree that continuing to obtain consent for the use of cookies is a very good idea, and continuing that practice or commencing that practice if that's not something that you are already doing. A second practical point is to look at whether you can contract with Google Ireland rather than Google US if using tools such as Google Analytics or indeed other providers. This then sort of puts the burden of the transfer on Google itself. So if you're transferring to Ireland, then obviously that is within the EU, or it's an adequate country from the UK perspective. And therefore it becomes Google's responsibility to then deal with that onward transfer. The third thing that you can do are various settings within Google Analytics to kind of reduce the risk. So the first one, as was sort of commented really in both of the decisions, is ensuring that the IP anonymization feature is turned on. Now, actually, there was an announcement from Google just yesterday that I'm not sure quite when it starts, but within the Google Analytics version 4, that will no longer be storing IP addresses. And so Google announced that just yesterday. And so that at least mitigates some of the risk depending on what other data, personal data you're transferring. There are other settings within Google Analytics that can be activated. These include a data sharing setting and also turning signals off within Google Analytics. These two settings are really related to how Google can use the personal data that's transferred for its own purposes, for example, for product improvement or to enrich analytics data with ad tracking data collected by Google about its users. And so deactivate or making sure that these this sort of processing can't take place and making sure those settings are activated is a sensible way to not be compounding the transfer problem with any other problems. Another thing that came out of these decisions was that some companies, in addition to using kind of Google cookies and IP addresses, are also sending their own proprietary IDs to Google Analytics. This was a particular criticism in the French decision, as it could lead to further differentiation of users and more personal data. So avoiding sending that kind of additional proprietary information will sort of reduce the risk further. And the final point we can make is that Google has also done its own transfer impact assessment. So obtaining a copy of that and reviewing it would be a sensible thing to do. We understand this is not available publicly, but it can be requested from Google on a request basis. So I hope that those tips will give you some comfort that you can kind of reduce the risk of using Google Analytics and similar mechanisms and reducing that transfer risk. We'll now go on to talk a little bit about Privacy Shield.
Before we do that, Rob, first of all, I hope people can still see my screen. I had a worrying message that it wasn't being shared anymore, but no one's complained, so I guess that you can. A couple of questions for you. Is the Austrian decision subject to appeal?
I believe that there was an appeal date in it. I think from memory it might have been about 30 days, but I think the decision actually came, I think it was actually made, I think in December, even though it was only published later, or was it November and then published in December? So it might be that any appeal process has sort of come and gone already. I'm not aware of what appeal has been made and what the outcome of that was.
Okay, thank you. And the second one is, has the ICO said anything about Google Analytics?
I haven't seen anything recently.
No, not me. And they're not part of the one-stop shop, of course, or coordination, international stuff.
Which perhaps that's a benefit for UK-only based companies.
Perhaps that's a benefit. Thank you.
So Privacy Shield 3.0. Well, I think anybody listening to this presentation might have become a little bit disheartened about the state of privacy law and all the things that we have to think about. But there is a bit of a ray of sunshine on the horizon. So in terms of Privacy Shield 3.0, is that something that is going to come about? Well, hopefully, because really the issue of transfers to the US is, it really requires a political solution rather than a legal solution at the end of the day, because the US is obviously going to continue to use surveillance, and that's not going to stop anytime soon. And so the EU and the US really need to work together to find a political solution which will take into account the CJEU's Schrems II decision and allow that data to continue. So what have we heard about this? Well, negotiations have been ongoing for the last almost 2 years since the Schrems decision, and we do believe that they might be getting close to some sort of conclusion. We have heard that it's a possible date for an announcement could be in May. This is when the Trade and Technology Council, which is the joint trade body between the EU and the US, who is discussing a successor to Privacy Shield, is meeting. So that's in May. So I think we should all cross our fingers on that. And that leaves us with 2 questions, really. What will it be called? And what will Max Schrems do next? And I don't know if you're a betting man, Renzo, but I would only bet on the answer to one of those questions.
Well, indeed. If there is a Privacy Shield, is it 3.0? Is it 2? We never called Privacy Shield Safe Harbor 2.0, did we? So, but the Schrems one, you weren't yet a privacy lawyer then, Rob. But Schrems 1 was 2015, of course. Schrems 2 was 2020, and Schrems 3. Killing the new Privacy Shield, my prediction will be 2025. But thank you very much for that, Rob. Thanks, Natalie. As predicted, we got time for some more questions, and as a couple for both of you, actually, and for me. First of all, Natalie, got a question about whether or not completing either the EU SCCs or the UK IDTA means that you don't need, or you do need, Article 28 terms. I think you did touch on it in relation to the UK, for both, in fact. Natalie, you're on mute. Oh, we lost Natalie. Okay, so I think the answer.
Go ahead. Go ahead, Renzo.
No, I said the answer is the EU SCCs makes an attempt at dealing with the Article 28 provisions, but there is a gap or two. There's a bonus question if anyone knows what the gap is. The one that I notice in the EU SCCs is that under Article 28, the processor is supposed to provide assistance in relation to data protection impact assessments. And that's not there, although there might be some general language which captures it. But the UK document, as Natalie said, and it's a nice point actually in it, is it doesn't try to deal with Article 28. It deals just with transfer issues, protecting the data in accordance with the UK law abroad, rather than with processor controller provisions. Natalie, another one for you, if you're now with me, which is the following. There's a couple of questions in relation to UK transfer risk assessment. That was out for consultation, wasn't it? What happened with that?
Yeah, that's right. So there were 3 documents that were subject to the consultation. So the 2 documents that I've discussed, which were obviously sort of finalised and put to Parliament. And then the 3rd document was the UK's International Data Transfer Risk Assessment tool. And I suppose it's the equivalent of the EDPB's guidelines on supplementary measures, which sort of takes you through step by step how you would go about conducting a transfer risk assessment for UK data transfers. So obviously it's still in draft. We've seen the document that was produced for the consultation for consultation purposes, but it hasn't been finalised. When the ICO put the two transfer mechanisms before Parliament, it did kind of provide some sort of assurances that we can expect some more guidance to follow, including hopefully a finalised version of the assessment tool, and also some kind of clause by clause guidance on the IDTA itself. On the risk assessment tool itself, it actually was really helpful. It's very user friendly, in my view, more so than the EDPB guidelines. You know, it has flowcharts and it does provide you a framework to kind of assess risk with a, you know, red, amber and green sort of process. But I think the main takeaway that I have is that for the same reasons as I've explained why you would be using the UK addendum, I think that the you know, you're more likely to be using the European framework for your UK transfers than you are the UK assessment tool. Because obviously when you're assessing risks with data transfers, you're looking at the territory that you're transferring the data to, as well as obviously the context of the transfer. So I can't really imagine a scenario where you're transferring both UK and European data of the same nature and for the same purposes to the same territory, and you would conduct a separate EU, if you like, assessment and a separate UK assessment. So I suspect in most cases that you'll be using the European framework as opposed to the UK assessment tool, even though it does have some sort of helpful aspects to it, certainly in its draft form. So I hope, does that help to answer that, Renzo?
I think it does, Natalie. Thank you very much. I think we've got time for a couple more. One I'll take, and then Rob, one coming your way. The one I'm taking, do we see folks using, and it's harking back to my part of the presentation where I showed two approaches to undertaking transfer risk assessment, what I call the robust approach, and the other end of the spectrum, a risk-based approach. Do we see the first approach being taken with the US and the second approach with other countries? It seems that the risk-based approach would always say that no transfers to the US are allowed. Well, I'm not sure about that, but I do see. Yeah, there's a spectrum of different approaches here, and what I have seen with some clients is, you know, for key transfers, structural transfers, certainly intra-group transfers, you might go for a proper full EDPB recommendations approach, and for more occasional vendors or countries which are less susceptible to automatic criticism in the eyes of Mr. Schrems and others, i.e. not the US, to take a more risk-based approach. So horses for courses, appetite for risk and appetite for spending money, because it costs money to do robust analysis here. If you think about the resource that the European Commission put into ensuring or checking the adequacy of protection of data when they make their adequacy decisions. Rob, a question for you, to in relation to Privacy Shield 3.0. First of all, and I think they relate to each other actually, so I'll give you both, have our clients expressed trepidation about investing again in Privacy Shield 3.0? And then a related question is, do people who maintain the original Privacy Shield get any benefit when the new Privacy Shield 3.0 comes along?
Okay, well, I think some clients have taken different approaches to whether to invest in Privacy Shield, or indeed whether to continue the existing Privacy Shield certification that they already have. Some clients have decided, well, actually, we don't know what's going to happen. Let's not spend the money. And let's rely on, protecting the data through other means. Other clients have sort of thought a little bit ahead and asked the question, well, if we're registered for Privacy Shield and we continue that certification, will that allow us to sort of jump the queue and sign up to whatever the successor will be? I think we don't know the answer to what that successor is going to be, what it's going to look like, whether it will require any sort of new certification, or whether people can continue under the old certification, perhaps with some additional measures by the US government or additional promises about how EU data will be treated. So I think it's a bit of a mixed bag there, and I think it depends on the cost and what you're predicting.
Thanks, Rob. So we are on the hour, so it just leaves me to thank you all for joining. I hope it was helpful and gave you some answers, if not all answers, certainly not in relation to the Privacy Shield 3.0. Not your fault, Rob, in that we haven't yet seen it, so we'll see what happens. We didn't get a chance to answer all the questions that came through, but we will follow up with email in the next week or two. We'll send slides, we'll send a link to the recording. We do try and deliver a webinar every month or so, but in April we have in fact two. Rob again will be featured, this time on anonymization with Hazel Grant, our head of team, and then a team led by my partner Leonie Power will cover ad tech, inspired of course by another important development, the Belgian decision on IAB Europe's transparency and consent framework. Thank you very much, everyone. Bye-bye.